Number 61, matter of Honorable Robert J. Putorti. Good afternoon, Counsel.
Good afternoon, and thank you, Mr. Chief Judge Wilson. Nate Riley for Justice Putorti. And may it please the Court, with the Court's permission, I would like to ask to reserve 3 minutes for rebuttal.
Absolutely.
Thank you. This Court only exercises its authority to remove duly elected judges upon instances of truly egregious misconduct or circumstances. And the alleged aggregate misconduct here did not meet the very high standard in this case involving, at worst, imprudence or very poor judgment. And there were many mitigating circumstances not adequately considered by the CGC below. In accordance with the dissent below, this Court should reject the sanction of removal. First, the advisory opinion 18-165 and Judge Hobbs' memos should have foreclosed further inquiry into brandishing the pistol or waving it toward Defendant Wood for many reasons. But in any event, should result in no more than censure here. According to 18-165, Justice Putorti's supervising judge, Judge Hobbs, remained in the best position to assess the motivation and receptiveness to guidance.
How does the fact that there, in lieu of a hearing, here there was an agreed statement of facts stipulated as constituting the entire record? So instead of a hearing, everybody agreed that these were the facts. And did petitioner admit he was not justified in brandishing a gun at the litigant, that his mention of the litigant's race may have created the appearance of racial bias, and that he violated the rules as charged in charges 1 and 2, including that he failed to perform his judicial duties without manifesting it in words or conduct, bias, or prejudice based on race?
Judge Chapman, there's a couple of things there that I'd like to take in order if I could. I think we tried to address this in our reply brief, that this was the essential issue in this litigation. In our reply brief below, and I believe in our reply brief below, which is in the record as well, the issue of whether or not there was racial bias here was the central issue. And so we were not conceding that by indicating that, by making an acknowledgement.
So what was the effect of the acknowledgement?
I think the effect of the acknowledgement was just to say that this is the issue that is before the court, and to present the legal issue as to whether or not his conduct, which was no more than relating that this was a large black man that was rushing the bench,
So
whether or not
it didn't
that
have a
constituted.
hearing.
Correct, there was no hearing.
So the record is the record that you agreed was the record, correct?
That is correct. That is the record that we agreed. But again, and I think we approached this in our reply brief by distinguishing between what would be considered an acknowledgement and an admission. And I don't think that there was an admission here. I do think that he does acknowledge what happened in this case, which is that there was what he relays is a large black man approaching the bench, and he subjectively feared. And then to get to your Honor's second point as to whether or not we...
Was that an accurate assessment based upon the description of, he was 165 pounds, I believe, just 6...
He was 6'0", and he was 165 pounds, correct. So I think that he's accurately reflecting both his race and obviously his gender, but he provides, there's some variance as to the stature of this individual. And I think that the variance as to the stature of this individual could demonstrate racial bias, right? If you're saying that this is an individual is so large, is larger than life, and he's coming at me. But I also think that it goes to justification, and I think that's what he was trying to get at, was that he has this large person that's rushing towards the bench, and he doesn't...
He didn't agree that there was no justification? Those stipulated facts?
So I think we arguably agreed that as to the objective portion, so there's an objective element and a subjective element to any sort of a justification defense under this court's decision in Ray YK and some other cases. And I think arguably as to the objective portion, whether or not the individual rushing the bench without a weapon, I think that is where we would probably have to concede that that did not constitute deadly force that was approaching him. However, we cite some cases in our briefs that it would still be appropriate for him to brandish a gun, particularly a gun that has not been racked and loaded, to dispel that potential threat. So subjectively, I don't think that we did concede at any point that he had the subjective fear of the individual that was approaching him at the bench.
And why was that? Are you saying it's because he was a large black man?
Because he was rushing the bench. Because, and again, in the record, I think that it's also stipulated too that there are no other witnesses to this event. There's just the two of them. All right, there's my client, Justice Putorti, and the individual defendant Wood, who are there. And it's according to Justice Putorti, who retells us this incident multiple times, the individual is rushing towards the bench. In one instance, he says that there was security there, but we know that there was not security there from the security guard saying that he has no recollection of it, which is also in the record. And so he subjectively feared that this individual who had been charged with a serious
Wasn't it your
violent felony.
client that said there was security there?
I'm sorry, Judge, I was speaking over.
Was it your client that suggested that there was security there and that they had some conversation about how quickly he did what he did?
So in the Judge Hobbs memorandum, the Judge Hobbs relays that Justice Putorti does indicate that there was security there that day. But in our agreed to statement of facts, as Your Honor has pointed out this morning, the agreement was, and I think it's in paragraph, I want to say 16, that there were no other individuals there that day. So as to the record that's on appeal here, yes, there was inconsistency, but
In this instance, you have a person who is a judge, and we have the rules with respect to judicial conduct and how judges are to perform their duties. How does his conduct impact? And it doesn't have to be actual, the appearance of bias and prejudice and that. How does that affect his ability to go forward and be an impartial arbiter and for the public to have confidence in what he does if he's not removed?
well, I think the public, at least within his community, does have some confidence instilled in him still, based upon the fact that he was reelected following this incident and following the investigation here.
So
But
you're
to answer
saying,
your-
as a judge, it's just limited to the people that elected him? It is not as to how it can impact the judiciary as a whole?
No, but I do think that that is some indication as to whether or not the public has lost confidence in him, right? And I think that the standard is the public and not just the judiciary. If
But
he would-
you're saying his public, the people that elect him. So it doesn't matter that it may badly reflect upon the judiciary as a whole outside of his elective community? Is that what you're
I guess I have to
suggesting?
resist Your Honor's question that I don't think it reflects poorly in that he did subjectively have this fear of the individual, right? If he was just randomly pulling his gun out of any litigant for no purpose whatsoever, I think I could agree with Your Honor that it would reflect very poorly upon the entire judiciary if we were to allow that to continue. But that was simply not the case here. And I think it's uncontradicted in the record that he did have the subjective fear of the individual that was rushing towards the bench.
So let me hold you up on that over here for a second. So I may have misheard you earlier, but I thought I heard you say that because the judge had a subjective fear of this defendant rushing the bench, he was justified in brandishing his weapon. Did I mishear that?
No, Judge. I think that
So that's a fair statement of your position.
I think that it's arguable as to whether or not he had justification here under 3515 and under, we cited a case from, albeit from the third department.
I'm sorry, so what does arguable mean?
I'm sorry, Judge. Our position is that with respect to the Ellis case, which we think presented similar factual circumstances, that there was an individual, he used a knife and was swinging it at the person
Yeah, but this
that's
guy's
approaching
unarmed, so I'm asking something different,
him. Okay.
right? If a judge is on the bench and the defendant is rushing towards the bench, let's take that, and the defendant is unarmed, right? And the judge has, in your words, a subjective belief that he's in danger, it's okay to brandish a weapon, a firearm. That's justified.
That's our position according to the Ellis case, yes.
And that's your position here today.
Yes, Judge.
So then I don't understand why you want him to be censured. What would we be censuring him for?
Well, we don't. I mean, in our brief, we asked that he not be censured, that there be no admonition.
Oh, I thought you were earlier asking that the.
It would be no
penalty
worse
is
than.
Censure.
No worse than censure, because the proposed punishment here has been removal. And so that's what we're seeking, is to reduce this from removal.
But you really
because of
think he did nothing wrong if we take as a fact that he subjectively believed he was threatened?
Correct. And we also, we make similar arguments with respect to the race issue, Judge, which my opponent believes, or I'm sorry, the CJC presented below, constituted a bias and prejudice in that he described him as a large black man. We do not feel that in any way demonstrated racial
What does
bias.
the black add to the threat?
I'm sorry, what does what?
What does the black add to the threat?
Absolutely nothing, Judge. He's retelling the incident to other individual. He's accurately retelling that incident
I
as
suppose,
somebody.
but he didn't describe what clothing he was wearing,
Correct, he did not.
because that was irrelevant to the threat.
Correct, that would be irrelevant to the threat.
Okay.
So,
So your view is that no matter how objectively unreasonable a subjective fear might be, the subjective fear nonetheless shields someone from any action?
well, it depends upon the charge at issue, and that's one of the issues that I have with this case. So if you're charged with a serious violent felony, and if it was, then potentially, no, I would be incorrect there. But this is why we argue that 18165, we think, does not make for a good analytic framework for looking at these issues, because it requires that supervising judge to get into very complicated issues of what type of threat was presented, whether or not the individual, the judge, in that case, adequately retreated, things that are not going to be typically in the record. And you're going to have to ask some very difficult questions as a supervising judge of that, the judge that you're supervising there. But so it really depends upon, the circumstances presented. And here we're arguing that.
So again, just so that I'm clear, your position is, even if it is objectively unreasonable, if your client or any judge in this state subjectively believes that they're in fear, they may pull out guns on litigants.
So I may be saying this poorly, but in the case of People v. Ellis that we rely upon for that position, there was the use of what would be considered deadly force and the use of a knife that was used to ward off somebody. And in that case, the court said that the individual would be entitled to a justification charge under those factual circumstances, where the individual that was charging towards them did not have any weapon.
But those are people, and these are judges, and we hold judges to an even higher standard.
Absolutely, Judge.
And in this case, I think the point we're all sort of circling around is that even his subjective belief has to be evaluated under some sort of reasonableness standard.
It does, and I think what's even more instructive is just some of the other cases in which the CJC has evaluated the discharge of weapons and decided that there has not been any sort of, that there's been no more than a censure or admonition in those cases. We specifically rely on Siganek, in which an individual shot at turkeys near bystanders, which was certainly much more egregious conduct than what occurred here, where there was no discharge of any weapon, and that individual was only admonished.
Shooting at turkeys
In a crowded street.
in a crowded street, wholly inappropriate, but you're saying it is not as egregious to point at a litigant who is before you to receive an adjudication of their case, and they're supposed to thereafter have confidence in the judicial system, that they're an actual litigant in the courtroom.
Right. I think that not discharging the weapon is less egregious than discharging the
Doesn't
weapon.
matter where it happened.
I think the circumstances absolutely matter, and I think that the circumstances in both Siganek and Segula, where again, the firearm was discharged in chambers accidentally, and that judge was only censured.
We're in the courtroom,
Right,
pointing
that's-
it at a litigant. What impact is that?
Right, so that's kind of what I'm getting at. In the Segula case, that was another instance in which there was a firearm in the courthouse, and that firearm was actually discharged, which is arguably much more egregious conduct than what occurred here. And in that case, that individual was only censured. And so that's.
Counsel, didn't the commission also consider his subsequent conduct? I think they described it as a lack of insight into the gravity of the misconduct, I think namely telling this story on a number of occasions after the incident.
So if I could, there's 4 occasions in which they're talking about him retelling the incident, and I think that the retelling of the incident only matters with respect to, the repeatedly retelling of the incident only matters with respect to whether or not it demonstrates racial bias. And in a few of those instances, there's no mention of race whatsoever. In one instance, he's telling it to the cousin, who then publishes the article with Hofstra University, and there's no mention of race there.
You didn't say large black man for the article?
I don't believe there's any indication of large black man for the article. He does talk about large black man or a football player-sized individual when he's describing it to Judge Hobbs.
It is
And Judge
only
Hobbs
after it's published, he's proud of the article, then race starts getting inserted, and reinserted?
Yes, I think that the first instance of race that we see in this came after the article, yes. But the article and again, the article I think demonstrates his pride in gun ownership, his pride in exercising his Second Amendment right. I think that the article actually
He's a judge. We're
Yes.
supposed to be looking at him as a judge. And judges, with respect to rights that we have, are lessened because we accept the judicial office than general citizens. We have to conduct ourselves in a certain manner, and in a manner that does not negatively impact on the administration of justice and our ability to fulfill our responsibilities. And you're saying here, the judgment of retelling the story in the way that he told it is evidence that he's not biased?
Yes, because I think in the first instance in which he retells it, there's absolutely no mention of race. In the second instance in which he retells it, when he's describing it to the judicial conference, there is a mention of race, but it is an accurate mention of his race. He says a large black man approached the bench. I don't
And
think
it's
that
not
it was,
evidence of a stereotype?
No, I think the CJC wants to focus upon him mentioning his race, but I think the larger point here that he tried to make, and that we're certainly trying to make on appeal, is that this was a large individual that was rushing towards the bench, and that he had.
Wasn't your argument with respect to the racial description at some point that it was for purposes of accuracy so that he was correctly identifying who it was that was rushing the bench?
Yes, and he had an obligation to do that when he was speaking with Judge Hobbs, because this is a very serious incident that
Okay,
Judge
but
Hobbs is investigating.
what's your obligation to do that at the judicial conference? I mean, why is it so important that you communicate to a gathering of your peers at a symposium on security that the person who rushed the bench was black?
I think he's just according to the record, he's asking everybody else there for guidance as to what occurred in that incident.
Guidance for when black people do it as opposed to other people?
Fair question, Judge, as to whether or not it needed to be mentioned, but I think that he did not need to. Perhaps he did not need to mention his race, but he did need to provide an accurate description to those individuals so that they could assess whether or not his conduct was appropriate given the threat that he faced at that time.
Thank you, Counsel.
Thank you, Judge.
Chief Judge, Your Honors, may it please the Court, and Robert Timbechian for the Commission on Judicial Conduct.
Can you help me with what is the impact, if anything, of the stipulated facts and record?
Stipulated facts before you are the record on which the Commission made this decision, in which this Court must decide whether to uphold that decision. Judge Putorti waived his right to a hearing. He waived his right to cross-examine witnesses, and he signed with counsel, the same law firm that's representing him here today, the facts that were before the Commission and that are before you. And in that record, he admits that in the courtroom, he was not justified to brandish a loaded weapon at an unarmed defendant, evidently for coming up too fast in front of the line.
The stop line.
The stop line, so to speak. He admits, and the record shows, that there was a uniformed officer at the bench who did not see this supposed provocation. He admits that there was an assistant district attorney before the bench who did not see this supposed provocation, because he admitted and stipulated on advice of counsel that if those people were called, they would not have been able to testify that they saw this provocation. He, in fact, went on to say that he had what would have been a memorable exchange with the uniformed officer at the bench for his own security, who supposedly joked, "You're pretty quick on the draw,"
So what
and
you're saying
stipulates
is
that that
if he
officer
had-
has no recollection of that
But
conversation.
if he had not stipulated, there would have been an actual hearing where he could say he reasonably believed he had subjective and objective reasons for the manner in which he acted.
Yes, if there had been a hearing, he would have had the opportunity to cross-examine these witnesses that we would have put on, but I would urge and submit to you that the result would have been the same, which is why he stipulated to it in the first place. And that's what the court really is presented with here. In the courtroom, he did something that no judge should do. without justification, he brandished a loaded weapon at an unarmed defendant for coming up supposedly too fast, something that I would imagine that any trial judge with experience in New York at some point or another has had. People are anxious in the courtroom, and they sometimes cross the line. Yes,
Can I ask?
Please.
You, in your brief, explain why you think a couple of cases cited by petitioner that involve sanctions less than removal
yes.
are distinguishable. What case or cases would you point us to where the commission has imposed the sanction of removal that you think are analogous? It's obviously the most, extreme sanction that can be imposed.
I don't think there is an analogous case to this. I think this is sui generis.
So what
I am
other
unaware in my
circumstances?
40 years of doing this work that there has ever been a situation where a judge brandished a loaded weapon in the courtroom at a defendant under any circumstance, let alone one in which he admits that it was without justification. All of our other removals for egregious behavior have involved facts really anomalous to this. This is really an unusual, extraordinary event. All the more reason, I think, for the commission to have treated it as seriously as they did. This is not the kind of thing that judges do or we expect them to do.
What was the status of security in the courtroom? Did I hear you say at the beginning of your argument that there was security in the courtroom?
There was a uniformed police officer at the bench.
Who just happened to be there, or who was assigned to be in the room with?
In this record, I believe it indicates that he is there for security purposes, not just that it was an accident.
Okay, because, I mean, there was something in the record about uniformed officers. It was adjacent to the police station, and
Yes.
uniformed officers would pass through, but that's not.
Yes, but here he was at the bench for security purposes.
Counsel, as I understood the commission's findings, that the subsequent conduct went more than to just exhibiting racial bias. It went to lack of remorse, and I think it might even be described as boastfulness somewhere in the...
Yes, even after this one-in-a-lifetime event in the courtroom, rather than show contrition until he was before the commission, he bragged about it. His co-judge used the term boasting or bragging to describe what he was doing when he showed the article that talked about how he brandished a weapon carrying in the courthouse. And then at several conferences with other judges, in addition to the one-on-one conversation with his supervising judge, he referred to the events and exaggerated, as he did the provocation in the courtroom. He exaggerated the circumstances under which he felt supposedly threatened. This big, large, black man, built like a football player, 6'9", was actually a 6 foot, 165-pound individual. He could have called him Mr. Wood, but he referred to him by race, showing a lack of real appreciation for the responsibility of a judge, on or off the bench, to behave without manifesting bias or prejudice. The race of the defendant was absolutely irrelevant to what happened here, unless in some way it's partly what motivated the judge to have whipped out the gun. He really didn't show in these boastful retellings that he understood or appreciated the responsibility of a judge. People come to a courtroom to resolve their disputes in reasoned, dispassionate circumstances. They have a right not to imagine that a judge is going to whip out a loaded weapon. Though there might not have been a round in the chamber, he acknowledges that it was a loaded weapon, and as he told Judge Hobbs, he could have put that in a flash into the chamber. He risked not only the safety of the defendant, but anybody else in the courtroom by whipping out the gun, and then by repeatedly bragging about it in conversations with other judges.
So if we sorry, Mayor,
Yes.
if we separate his conduct into the two pieces, in the courtroom and then afterwards, in the courtroom, at least my understanding is he said he's not bringing his gun to court ever again. I think is that right? That he said that he's not going to do that?
Yes, he says that.
Okay. And then for the outside of the courtroom behavior, there's at least a view of his conduct as kind of Walter Mitty-ish. Put the racial piece aside. Turning somebody who's 6 feet tall into 6'9" and football player and all this I don't know if you know that story, The Secret Life of Walter Mitty.
I do.
Yeah, but I mean, not clear to me that we want Walter Mitty on the bench, but putting the best spin on this, he made a mistake, a really bad mistake, but he says he's not going to put himself in a situation he's not going to do that again. And his overly exaggerating behavior is a personality characteristic that some people have. Should we just censure him?
No, Your Honor, because this court said in matter of Bauer, sometimes an apology is insincere, and at other times, no amount of a sincere apology can undo the prejudice to the administration of justice by the behavior that brought us here in the first place. Here, the prejudice to the administration of justice in a judge who is responsible for the dispassionate resolution of disputes and hopefully
What
the
about
finding
the
of truth.
suggestion that in his community, they still have trust in his ability to
It makes no difference, Your Honor. We apply an objective standard to judicial conduct and to judicial behavior. We have a constitutional scheme in New York for evaluating and determining and adjudicating complaints of misconduct against judges. The Commission on Judicial Conduct in the first instance, this court on review in the final instance. We don't make exceptions for a community in one part of the state that might re-elect a judge thinking this is the kind of person we want on the bench versus another part of the state where they might turn him out of office because they think the behavior is shocking. Subjective is irrelevant, and the view of the electorate in terms of determining whether someone has violated the rules to such an extent that their removal is justified is in the first instance for the Commission and in the final instance for this court. And I would add, given some of the observations that my adversary made, that it is not for the Advisory Committee on Judicial Ethics nor for a supervising judge to substitute their judgment for the constitutionally authorized entity that is supposed to make these judicial conduct determinations in the first place.
Because they can take certain actions, but then if the case is referred to you, it can be determined that that was insufficient, correct?
Correct. And we can't assume that Judge Hobbs in the first instance or the advisory committee later on had all of the facts before them. They certainly show no indication of having interviewed the assistant district attorney or the police officer in the courtroom, or having taken Judge Putorti's testimony under oath, or having spoken to his co-judge who said that he was boasting about it, or the other judges at various judicial conferences in which he brought this up. This is part of the record that was developed by this constitutional scheme that we have had in place in New York for over 40 years, and which I think has worked quite well for the Commission
Counsel-
first and for the court ultimately.
There's another set of behaviors here. There's the fundraising violation.
Yes.
We haven't discussed those. And I think, maybe you disagree, but those very often are not removable offenses, similar types of things to what happened here.
I would agree.
What do we do with that? Does that get added into the sort of totality of the circumstances with respect to the penalty here? Does it push it over the edge if you're on the fence with regard to all the other stuff? Or does that exist separately in its own universe?
I think we look at the conduct here as a whole. If the only thing we had were the fundraising violations, Judge Canatera, I would not have recommended removal, perhaps an admonition, under certain circumstances, perhaps even a private caution, particularly if it had been a first-time event and the judge was now sensitized to his behavior. What makes these fundraising violations significant is that they occurred after he knew and while he was under investigation by the Commission. He knew that his ethical obligations were being scrutinized at the time he, unrelated to the gun event, committed these other violations, which the Commission rightly concluded suggests that he did not really appreciate the role and responsibility of the judge and his obligation to abide by these rules. He demonstrated a cavalier attitude toward his ethical obligations when, knowing the Commission was looking at him, he went ahead and committed a whole bunch of other violations for all the world to see because it was on social media, not just in the closed environment of a courtroom, which of course, obviously, he then broadcast by doing this interview and then talking about it with various other judges. It demonstrates as a whole that this record reflects a judge who reacts without thinking, who doesn't have a real sense of decorum, doesn't really appreciate the ethical mandates that are imposed on him and on the entire judiciary. And so for that reason, bad as the gun episode is by itself, and if charge one were the only thing we had, we would still be discussing removal here. The fundraising violations really compound the picture, and for the commission really left no doubt or option, and I would respectfully request the same of the court.
Thank you.
Thank you.
If I may, very briefly, when I was responding to Judge Troutman's question earlier, I referred to paragraph 16 of the stipulated facts where, and it says that while Mr. Wood was on the court premises, respondents brandished a gun at him, notwithstanding that Mr. Wood was not acting in a manner demonstrating deadly force. There were no other witnesses to this event. And so there was not security, according to the stipulated facts, on that day. And all we have to go by were the two statements of my client and Mr. Wood. Mr. Wood was not investigated here, or was not part of the investigation by the CJC. As to the mitigating evidence here, I think as the dissent recognized below, and as the lower court majority opinion failed to recognize, there was abundant mitigating circumstances that existed here that should reduce any sort of penalty from removal to a sanction, to a lesser sanction. There was no history of any prior discipline for Judge Putorti prior to these incidents. He fully cooperated with the CJC in their investigation. He entered into the agreed statement of facts, which thereby allowed them to review the evidence without having to subpoena any witnesses or have any testimony. He responded to interrogatories by providing them the only financial records in this case that establish the evidence as to charge 2. You see that in, I think it's November of 2020, he's asked, the interrogatories are sent to them in December. He responds by providing them all of the all of the attendees for all of the functions and also all of the financial information there. And so he was fully compliant with the CJC's investigation, and to suggest otherwise simply ignores that fact. And he wasn't trying to hide anything as he could have by removing the Facebook posts or anything during this investigation. He handed over everything that he had and essentially established the case as to charge 2 for them and explained, as he did in the record, his failure to recognize that even fundraising on behalf of an altruistic organization such as this court recognized in N. Ray Harris could lead to potential discipline. So there were mitigating circumstances here that were numerous. And as to the bragging or the boastfulness, again, I think I just come back to the point that he was boastful as to his Second Amendment right. That was the entire purpose of the article, was that he was trying to show everybody that, like, he was proud because of his heritage and because of coming up, because it's something that had been shared throughout his family history of his right to carry this weapon. It was not trying to be bragful or boastful that he did what he did with respect to an individual of race. It was only his Second Amendment rights that were important to him in terms of the bragging or boastfulness that occurred here. And so for that reason, we ask that you reject the sanction of removal and in your discretion enter no worse than a censure. Thank you,
Thank you,
Judge.
counsel.